Suspended Public Protector Busisiwe Mkhwebane's testimony continues in Parliament. Mkhwebane is fighting for her career at an inquiry that's looking into her fitness to hold office. Her testimony resumed yesterday following days of sick leave. But to discuss this even further, I'm now joined by Director at Accountability Now, Advocate Paul Hoffman, this afternoon. Thank you so much, Advocate, for your time, and good afternoon to you. Let's reflect a bit on some of the statements made here by Busisiwe Mkhwebane during her impeachment inquiry testimony. I mean, saying that investigating and holding the, and I quote, deep state is the reason that she's in this position now, because it seems that when you do probe this deep state and want to hold them to account, then there will be that resistance from them.
Yeah, I think she's rather overvaluing her importance in the scheme of things. The public protector is a creature of the Constitution. The Constitution in Chapter 9 created 6 separate institutions, of which the public protector is but one. And the function of all 6 is basically to bed down, support, as the Constitution puts it, constitutional democracy in South Africa. You'll remember that before we had the Constitution, we had a parliamentary sovereignty in which the majority of the votes in Parliament could be used in a way that was oppressive, and they were used in a way that was oppressive. In our constitutional democracy today, we have a supreme constitution, and parliamentarians, as well as Chapter 9 institutions, are constrained by what the Constitution allows them to do. And the mandate of the public protector, as set out in the Constitution, is simply to investigate allegations of impropriety, actions leading to prejudicial effects in the state itself and in the public administration. So if you start talking about a deep state, which is people acting outside the law, no, it's none of her business. It ought to be dealt with by the appropriate authorities, such as those in the Criminal Justice Administration and in the security services, and not in the course of the work of the public protector.
It seems, though, Advocate, though, even in as far as the judiciary is concerned, she further accuses judges of harboring this sense of jealousy towards her, explaining why she is being made a sacrificial lamb. So we're getting a sense here that, Busisiwe Mkhwebane is saying she didn't receive much favor or protection whatsoever from judges. As a matter of fact, it was more professional jealousy.
The judges are sworn to act impartially, without fear, favour or prejudice, in the work that they do. And in the case of Mkhwebane, they have done so meticulously at every turn in the way. Judges simply look at the evidence, documentation, argument that is put in front of them, and they make a call on the basis of their oath. They are obliged to act without fear, favour or prejudice, because that is what impartiality entails, and that is what they have sworn to do when they've taken office. And to suggest anything to the contrary is really an indication of how delusional the public protector has become in the course of defending herself in this investigation in Parliament.
I want to also talk about, her statement pertaining to the CR17, Advocate. I mean, she had mentioned during her testimony that there were absolutely no ulterior motives to her investigating what she terms as approximately or an estimated 1.2 billion rand campaign, almost amounting to those billions in as far as Cyril Ramaphosa is concerned, and the 2017 ANC presidential campaign. So there seems to be, another, allegation from the public protector that she's being attacked, for investigating these amounts, which almost fell onto her lap after that flow of money, that 500,000 Rand Bosasa donation was made. And then she says it's how she's come to investigate the CR17 campaign.
Yes, well, wait till she's cross-examined. She's going to have to explain to the panel that she's now appearing before how the conduct of an election campaign within a private political party, which is what the ANC is, has anything to do with her at all, because it doesn't. It's not part of her mandate. So she's delusional if she thinks that she is able to investigate the fundraising that went on in the CR17 campaign, because that campaign was aimed at making Mr. Ramaphosa the president of the ANC. It's got nothing to do with state affairs and nothing to do with the public administration. It doesn't even cross the boundaries of the executive members' Ethics Act. So yeah. I don't see how she can possibly claim jurisdiction in respect.
And I suppose, in my last question to you, speaking of funds, I mean, we know that 10 million Rand has been spent on her defense so far. We understand that it seems the funds are, slowly but surely, getting, redeemed. I mean, they're getting finished in as far as timelines. The date, Friday, will be the final date with which those sums of money will manage to pay her defense. What impact or significance do you think this will have on her inquiry moving forward as she continues to give her testimony? The fact that money still needs to be pumped into her defense.
Yes, well, that is a matter between her and the state attorney. The Constitutional Court has ruled that she's entitled to legal defense. She doesn't have to appear alone and unprotected by counsel. And it's really a question of what is reasonable and what isn't reasonable in the circumstances. And most importantly, whether if she loses, she is obliged to repay the money. That is in the realms of her negotiations with the state attorney. It's not public knowledge.
All right, we'll leave it then. I appreciate you speaking to me. Director of Accountability Now, Advocate Paul Hoffman, thank you so much for making time for us this afternoon.